This
Miss
call is
Anjali
now
and
being
other
recorded.
learners for today's online academic counseling session of the PG Diploma program in patent practice. I request Mr. Ramanamurthy, academic counselor, to continue the session. Thank you, sir. Please go ahead.
Okay, okay, sir. So as yesterday I was discussed about today's class, that is today we start a new paper. It is known as International Framework Patent Protection. So what is this International Patent for Framework for Patent Protection? So basically in this paper we exclusively deals with the international establishments like agencies, treaties like that, WIPO administrative treaties, Paris Convention, Patent Cooperation Treaty, Patent Law Treaty, World Intellectual Property Organization, how it is establishments, what is the working of this WIPO. So this should be dealt with in this section. So first, what is this uh, Paris Convention? First, initially, uh, before the 19th century, there was no such type of uniform legislation throughout the world which exists to protect the intellectual property rights. So, so it is difficult for a patent holders to protect their patents or to protect their intellectual property rights. So, to mitigate this problem, the international community, the so-called big powers, take a small initiation by saying that they would make some conference with regarding to like that. So in 1873 at Vienna, so the then government of the Empire of Austria and Hungary invited some countries to participate in a conference which will reflect that to make some policies with regarding to uniform legislations in entire the world with regarding to the protection of intellectual property rights. But due to inadequate legal protection which was given in that in that meeting, so very less amount of people also participated in the meeting, so this was not possible in that time. So later, during that year only, in 1873 only, but later, there is one more Congress was happened in the Vienna. In this Vienna conference, they are thinking that this was if you are not allowing to protect the intellectual property rights universally, then it became very horrible situation. So they want to convene a diplomatic conference uh, to deal with that unified legislation, unified universal legislation with regarding to protection of intellectual property rights. So consequently, in 1883, so the Paris Convention, the diplomatic conference was happened. So this Paris Convention for the protection of industrial property, often simply referred as Paris Convention, is a landmark international treaty governing the protection of industrial property rights. So the aim of this Paris Convention is to establish a framework for international cooperation in the field of intellectual property, particularly in the areas of patents, trademarks, and designs. So, what is the historical background of this intellectual property, this Paris Convention, and what are the objectives of this Paris Convention? So, as already we discussed, the Paris Convention roots in the 19th century period marked a significant advancement in the technology and global trade. So, the need for a comprehensive international agreement to protect industrial property, it becomes increasingly apparent. So during 1883, the first international conference on industrial property was held in Paris. So it lays down the groundwork for Paris Convention. In 1884, the International Union for the Protection of Industrial Property was established. In 1967, the Stockholm Act of the Paris Convention was adopted, updating and expanding the original provisions addressing contemporary challenges. This leads to the establishment of the World Intellectual Property Organization in 1967. So this is the historical background of the universal legislation, happening of the universal legislation to protect the intellectual property rights. So the object of the Paris Convention is simply the process of protecting industrial property rights in multiple countries to prevent unfair competition and to foster innovation and technology along with the economic development. So what are the provisions of Paris Conference? So basically, the provisions of Paris Convention can be broadly subdivided into 4 categories. That number 1, we are already discussed this right to national treatment. Number 2, right of priority. Number 3, some independent rights. Number 4, it is a administrative framework with regarding to the application of this convention. So the Paris Convention can be subdivided into 4 categories. In the first category, it gives a basic rights known as right to national treatment. In the second category, another right is there, that is right of priority. In the third category, there is common rules with regarding to particular patents. And the fourth category, you can deals with the administrative framework of the convention. So what is national treatment? So here the member state national treatment must treat foreign nationals and the same as their own citizens regarding the protection of industrial property. What is national treatment? The national treatment means, as regarded to the protection of industrial property, each country, those are party to the Paris Convention, must grant the same protection to nationals of the other member countries as it grants to its own nationals. So that means if the country was a member of Paris Convention, that the foreigners, if 2 countries are the members of the Paris Convention, then one country should treat other country citizens as treated with his own citizens. So there is no discrimination should be there while treating. But this is also required, especially this national treatment is talks about the member countries. For example, what about the non-member countries? The countries which are not participated in the Paris Convention, how it should be treated the others, the foreigners. That means here there is another criteria was given. Even it also grants to the nations of the non-member countries if the persons who are applying the patents or patent holders, if they are domiciled in the member state or having a real and effective industrial establishment in such country. So if either of these 2 conditions fulfills, then it can be called as national treatment. So then that person should not be discriminated, even though he is not the citizen of that country. What is the difference between domiciled and resident? It is important in this case. So there is a thin line. If domicile and resident, if a person, assume that a person is from Tamil Nadu, he wants to do some job in Delhi for a particular time of 10 years. Then if he go and do that job and there is no intention to stay there forever, so the intention is to do the job in the state of Delhi, then that person is called resident of Delhi. What about domicile? If the same person with intent to create his home in the state of Delhi, even though he is not the citizen, not the resident of Delhi, but after he getting the job, his intention was, no, I don't want to come back to again Tamil Nadu. I want to stay in the Delhi itself only after the completion of my job also. Then that person can be called as domicile of the state. So basically, according to this national treatment, the member countries can not discriminate the citizens and foreigners, even though the non-member country, the convention said that if that person are domiciled or having a real and effective industrial establishment in the member country, then he also not be discriminated. So the national treatment rule applies, first of all the nationals of the member countries. So the term national includes both natural person and legal person. What is the difference between natural person and legal person is important. The natural person means the human beings who are born by nature itself. Then it is called natural person. Legal person means even though he is not a natural person, law creates some rights to him. For example, a company. Company is a legal entity. Or for example, a limited liability partnership is a legal entity. But partnership is not a legal entity. Remember that. The company is a legal entity, but the partnership firm is not a legal entity. So because of that, there is a thin line between natural person and legal persons. So the nationals here, the national treatment, the nationals includes both natural person and legal person. And this national treatment further includes that any requirement of reciprocity of protection is excluded. What is this reciprocity of protection means? Suppose that, for example, country X is there. Country X has a longer term of patent protection than country Y. Both are members of Paris Convention. In such case, X country will not have the right to provide the nationals of Y country. It will enjoy a term of protection of the same length as the term of the protection in the law of their own country. So this principle applies not only to codified law, but also the in jurisprudence and the practice in the patent office. This principle also applies. This is called reciprocity. At the same time, this, according to this Paris Convention, some exceptions also given to the national treatment rule. What are these exceptions? Number one, in the case of judicial and administrative procedures. So the Paris Convention allows countries to impose certain administrative or procedural requirements on foreign nationals that may differ from those imposed on domestic nationals. For example, a country can require foreign applicants for patents or trademarks to appoint a local representative or agent within the country to handle legal proceedings such as the patent disputes or trademark oppositions. Next, the second right is the second section of rights that is known as right of priority. What do you mean by right of priority? So the right of priority means if you file a regular application for an industrial property, right, in one of the member countries of the Paris Convention, on the basis of that, you may within a specified period of time apply for the protection in all other member countries. We already discussed this in the previous class only, right of priority. So that allows an applicant to claim priority from an earlier patent, trademark, or design application filed in one member country when filing of for protection in other member countries. So the right of priority can be based only on the first application for the same industrial property right, which must have been filed in a member country. The reason for this rule is obvious, that is, one cannot permit an endless chain of successive claims. The length of the priority period is different according to the various kinds of industrial property rights. For example, for patents and patents of invention and utility models, the priority period is 12 months. For industrial design and trademarks, it is 6 months. So this comes under right to priority. And the third category of rights, which was given in Paris Convention, was provisions concerning patents. Provisions concerning patents. That is independence of patents. That means if the grant of a patent for invention in one country for a given invention does not oblige any other member country to grant a patent for invention for the same invention. That is, it means the invention in one country for a given invention does not oblige any other member country to grant a patent for invention. That means another country should not forbid that this was not patentable in my country, like that. Okay, so for example, if country X is there, if country X recognizes a patent, which is the country is the member of the Paris Convention. Now take country Y. The country Y is also the member of the Paris Convention. Now in this case, the country Y cannot say that the patent which was given by country X in their country is not patentable in country Y. So that is the independence of patents. So the fate of the particular patent for invention in any given country has no influence whatever on the fate of the patent for the same invention in any of the other countries. That was like that. Next rights is importation, failure to work, and compulsory licenses. With respect to importation, the provision states that importation by the patentee into the country where the patent has been granted of articles covered by the patent and manufactured in any of the countries of the Union will not entail forfeiture of the patent. That is nothing but if a person is there, a person was resident of India, but he went to the US. In the US, he applied a patent. So he got the patent in the US. For example, suppose that US is the member of Paris Convention. India is also the member of Paris Convention. Now, when that person returned back to India, in that time, India cannot forfeit the patent. Okay, because India is also member of that Paris Convention. So the patentee, the patent holder can easily take his invention to one country to another country if the countries were the members of the Paris Convention only. Next, compulsory license. So compulsory licenses for failure to work or insufficient work of the invention may not be requested before a certain period of time has elapsed. So that is, we are already talking about the right to priority. In the case of right to priority, initial the application is filed, subsequent application is filed, but during that initial application is filed, but you are not sufficient work was done, or you are not submitted the work within the meantime, then if the time period was elapsed, no need to take the compulsory license. So this compulsory license may also be granted for reason of the public interest in case where there is no abuse by the patent owner of his rights. Such situations may be in the field of military service, military security, and public health. Next right is patent in international traffic. So sometimes this may happen like by the patent holder, he may travel through the ship or aircraft. In that time, for example, if you think that a person X is traveling from America to Delhi, America to India, meantime he was the flight landed on Dubai. So Dubai was not a country member of the Paris Convention. In that case, what the patentee has right. So that is in the point of the question here. So the Paris Convention also deals with the transit of devices on ships, aircrafts, or land vehicles through a member country in which such device is patented. In such situation, the owner of means of transportation is not to be required to obtain a prior approval from the patent owner. So if in this case, other than patent, the previous right, we concluded that the patentee holder can take his patentable invention to anywhere. In this right, if a person was the transportation authority can make any permissions with regarding to this transfer of patents from one place to another place is no, it is not required to obtain a prior approval from the patent owner. So the next right is inventions shown in international exhibitions. For example, one invention was done by some X. Now the invention was displayed in the international exhibition. Can that invention should be required permission from the patent holder? So the answer is yes and no. The answer is yes in the case of if he is not used, if he is used for commercial exploitation. But if it is not, the answer is not when the patent exhibitions conducted by the state itself. So the member countries are obliged to grant in conformity with their domestic legislation temporary protection to patentable inventions, utility models, industrial designs, and trademarks in respects of goods exhibited at official or officially recognized international exhibitions held in the territory of any member country. So that's all. That is, if the exhibition was conducted by state, then no prior approval is required. But if that was conducted personal, then it would be required. So some grace period for payment of fees is there. With regarding to that, we are already said in the last two classes that if a patent was given, now you have to further taking the protection or for the enrolling the patentability, then you have to file a fee. So what is this grace period for the payment of fee or payment of maintenance fees? So the payment of maintenance fee, the grace period is 6 months. 6 months. 6 months is the grace period. If you are not paid during the 6 months, then due to this delayed payment, they will charge surcharge. So with this, we deeply discussed with regarding to Paris Convention. Now we further move to the Patent Cooperation Treaty and Patent Law Treaty. So these are the reforms done to the Paris Convention only. So Patent Cooperation Treaty and Patent Law Treaty. These are the two international agreements that have significantly streamlined and harmonized the patent application process worldwide. The Patent Cooperation Treaty, which was established in 1978, provides a unified framework for filing patent application in multiple countries through a single international application. So the Patent Law Treaty, signed in 1978 and entered into force in 1984, focused on simplifying and harmonizing the formal requirements of patent applications, utility reducing the administrative burden of the patents. So in the case of Patent Cooperation Treaty, it exclusively deals with harmonizing the patent application procedure. The Patent Law Treaty, it harmonizes the administrative procedure of this Patent Cooperation Treaty. So what is the Patent Cooperation Treaty? So the national patent system, in generally, the national patent system, it requires filing of application before every nations from where you need protection except being a member of any regional corporation. The regional corporation means we are everybody know that there is a SARC summit, SARC regional SARC, the full form is South Asian Association for Regional Cooperation. If in the SARC cooperation, they make an agreement that for SARC countries, if in any country, if a person applied for the patent, then it is not required to apply application in the other member countries of the SARC. In that case, except, but national patent system generally requires every applications before every nation. What this Patent Cooperation Treaty make that this Paris Convention also, it claim priority of an earlier application for application filed subsequently in foreign countries, but such a later application must be filed within the 12 months of the filing date of the earlier application. This was concern because 12 months is the filing before the 12 months is very difficult, because sometimes what will happen is in the other countries we cannot know how much they are charging to give the patentability, and at the same time what is the structural procedure to obtain the patent. In that situation, the time period of the 12 months is very less. So in that case, what happened is there is a lot of countries were saying that this is not good. So you have to revise this. So to revise the Patent Cooperation Treaty was adopted. So this Patent Cooperation Treaty basically for the universal application for the patentability. So committee In 1996, so there is an executive committee of the International Union for the Protection of Industrial Property by BIRPI. So this BIRPI is the predecessor of WIPO, World Intellectual Property Organization. This BIRPI is it is the acronym of French acronym with regarding to the Union for the Protection of Industrial Property. This patent cooperation treaty in 1970, the patent cooperation treaty was adopted in a diplomatic conference in Washington, D.C. So this in 1970, this Washington, D.C. conference, they adopted the patent cooperation treaty by enabling universal application, one application for the entire the members of the Paris Convention. So this patent cooperation treaty came into force from 1978. But initially, not so many members are there. Only initially there is only 18 members are there. Later it was expanded. So why this patent cooperation treaty was adopted, means that is to harmonize the procedure of filing of the patent applications. So the principal difference between national patent system and the regional patent system, such as those mentioned above, is that a regional patent system is granted by one patent office for several states. As I'm saying that in the SAARC case or ASEAN or BIMSTEC, if you take any cooperation, if they make an agreement that the filing of patent application in one particular country is enough to recognize the patentability in the remaining countries of that cooperation. So then one application is enough. So that is the regional patent system. Now, what is the function of this patent cooperation treaty? So the patent, first, what is the objective of the patent cooperation treaty? So the object of the patent cooperation treaty to improve on previously established means of applying in several countries for the patent protection for inventions. So this is the objective. So to achieve that objective, it was established an international system to enabling filing of the application. So what type of system they were adopted and how it is working, we have to see. So the functioning of patent cooperation treaty system. First, in generally, any national and resident of a patent cooperation treaty can file an international application. So that is the step one, filing of an international application. To whom a person, for example, let us take the person A. So he want to file an international application. Now, he can go to the respected nation. There is a receiving office is there. So in generally, the national office of any country can act as a patent cooperation treaty receiving office. So in the receiving office, you have to apply the application with regarding to the patentability. So this international application, it has the effect on the date of filing of your application. Of the application, you have to pay the fee. What the fee you have to pay is that you have to pay prescribed fee, which consists three main elements. One is transmittal fee, second one is search fee, third one is international fee. What is transmittal fee? So the transmittal fee is nothing but the fee which will reserve the receiving office. So the search fee. So there is another set of body which was established under Patent Cooperation Treaty System, International Searching Authority. This International Searching Authority will search. So this you have to pay some fee with regarding to searching to the International Searching Authority. That was included in this prescribed fee. The third fee is international fee. The international fee, it covers the publication of your patentable application, your patent application. So these three fees were prescribed. These three elements were prescribed in the fee. What is the language you should use in the application? So generally, the language depends upon the requirements of the receiving office with which the application is filed, and the International Searching Authority, which is to carry out the international searches. So basically, there are very less languages which we have to file. For example, Chinese, English, French, Germany, Japanese, Russia, and Spanish. These are the languages you have to suppose to be file an application on these languages only. After this application received, the receiving office, that is the national office, it makes this application into three copies, three documents. That is a record copy, search copy, home copy. The home copy, which it was the hard copy which they kept, that is known as home copy. Record copy, which the receiving office sent the international application to the international bureau, that is called search copy, record copy, search copy, and home copy. Home copy, the authority which they put themselves, that is home copy. The record copy, the receiving office is sending a copy to the international application to the International Bureau of World Intellectual Property Organization, that is the record copy. And it also searches another copy. It also sends another copy, that is search copy, to the International Searching Authority, whether to check in anywhere they are published or not, already they are patentable or not. So these three type of documents they have. Step 2. In step 2, it was gone through the International Searching Authority. That is, step 2 is called international search. Basically, for the international search, there is a high quality search of the patent documents and other technical literature in those languages is most patent applications are filed. So this high quality of the international search will be searched by the staff who are very exclusive qualified in the International Searching Authority to carry out the international searches. So the result of the search report. So after the searching, the International Searching Authority has to send the report regarding search report, known as search report. The search report will be published within 4 to 5 months after the filing of the international application. So the international search report may be favorable or not. If the international search report is favorable to you, that means the person who is making application, in which the citations of the prior art would appear not to prevent the grant of patent, then assist you in the subsequent prosecution of the applicants before the designated officers. If the search report is unfavorable, you have the opportunity to amend the claims in the international applications to better distinguishing the inventions from the state of art, or to withdraw the application before it is published. That is, when the International Searching Authority, while searching, if there is already a patent was available, in that case, what will you do? You have to withdraw or modify your application. Otherwise, if there is no applications, there is no not findings were available, then in that case, you need not to take. So with regarding to this search report, the International Searching Authority has to send the international search report to the applicant and to the International Bureau. The third step is international publication. So the international publication, basically, it has two main purposes. The first one is to disclose the public in invention. That is, in general, the technological advancement may be by the inventor. So what is the invention? So it should be disclosed because of this publication. Number second, it set out the scope for the protection which may ultimately be obtained. So that means on what extent the protection is given by these intellectual property organizations. So this was main purpose in the publication. So the International Bureau, which publishes the publication. In this publication, you should have, that means the publication which contains a front page setting out a bibliographic data furnished by the applicant, along with the data such that international patent classification symbol assigned by the International Searching Authority, the abstract, and also the description, the claims, any drawings, and the international search report. So the published document of the International Bureau must contain these all. So along with the PCT has the PCT means the Patent Corporation Entity has a gazette known as Patent Corporation Entity Gazette. So this report must be published. The publication document must be in through the PCT Gazette only. Next, these publication. What is the language of this publication? The language of the publication is nothing but the language which the international application is made. For example, if the international application is made in English, then you have get the published report in English. But there is exception. If the international publication was filed in other than the English, in this case, a translated document must be published in English. So what are the advantages of the patent cooperation treaty system? So the advantages of the patent cooperation system, basically it advantages to three categories. First one, it creates advantages to the patent office. Second, it creates advantage to the applicant. Third, it can create advantage to the national economy and industry. So how it can create advantage to the patent office? For example, in a country in the process of development, the number will surely rise considerably in the future, consequences of an increase in the country's intellectual industrial activity. So due to this, you have to maintain some advisory services also, technical advisory services. So in that case, because of this universalization, it will be easy to patent offices to give these technological advancements. At the same time, the patent offices can save a cost also. And if the international application has been published in an official language of the country, they can forgo publication altogether also. This is also another advantage to the patent office. So what is the advantages to the applicant? So the advantage to the applicant is nothing but he can file his application in his own country, number one. He cannot go to the foreign countries to seek protection. At the same time, he can spend less money compared to multiple applications. Next, what are the advantages to the national economy and industry? So because of this patent cooperation treaty, the universal application. So the universal application means once from a person X was filed an international applications with regarding to some patent of country A, then the country A name will be known to the entire members of the Paris Convention. So this increases the investments towards the nation, because if any technological progression happens in that country with regarding to this intellectual property rights for the adoption of any new methods, then the technological progress is essential for the national economic development. It gives, for example, investments come, then what will happen? A lot of jobs will happen, a lot of industries will happen. So a lot of industries will employ a lot of persons, and they will provide a technical skills to that local workforce. So the local workforce will be well equipped with that skills. So these are the main advantages with respect to the national economy and industry. So next, the patent law treaty. So what is this patent law treaty? So the patent law treaty, so it was adopted in 2000 through a diplomatic conference in Geneva. So the purpose of this patent law treaty is to harmonize and streamline formal procedure in respect of national and regional patent application and patents. So this patent law treaty talks about administrative harmonizing provisions. Any state which is a party to the Paris Convention for the protection of intellectual property, or which is a member of World Intellectual Property Organization, may become the party to this patent law treaty. So, as I discussed, that the patent law treaty mainly focusing on the streamlining the administrative procedures relating to patents, making user easier for inventors to file application and maintain patents across the different countries. These are all administrative procedures which should be streamlined by this patent law treaty. So, what are the key features of the patent law treaty? Key features, it includes standardization of requirements. So it harmonizes formal requirements for patent applications, such as the contents of the applications uh, from and the format of drawings. At the same time extensions. So it offers uniform time limit and produces procedures for extending deadlines, which helps applicants avoid the loss of rights due to missed deadlines. The third key feature is electronic filing. The patent law treaty encourages the use of electronic filing system to simplify submission process and reduce paperwork. And the another key provision is grace periods. So the treaty provides grace period for applicants to meet certain requirements like submitting missing document or paying the fee. And the last key feature is but not least, relief measures. So it introduced relief measures for applicants in cases of unintentional non-compliance with the procedural requirements, ensuring that minor mistakes don't result in the loss of patent right. So the patent law treaty does not deal with substantive patent law, such as patentability, requirements, or enforcement. It solely focuses on administrative aspects of the patent process. Next, further we have to move to WIPO. So what is WIPO? Basically, the WIPO is World Intellectual Property Organization. WIPO. So the World Intellectual Property Organization is a specialized agency of the United Nations. It is responsible for administrative international treaties concerning intellectual property rights. What is WIPO? WIPO is a global organization that promotes intellectual protection of intellectual property. It aims to ensure that inventions, creative works, and designs are protected and rewarded. So, number one, IP protection. World Intellectual Property Organization administers international treaties that provide a framework for protecting intellectual properties. Second one is IP services. IP services. WIPO offering a range of services to help business and individual protect and manage their intellectual property. And third, IP information. WIPO provides information and resources of intellectual property, including legal frameworks, best practices, and market trends. And the fourth one is global cooperation. So WIPO fosters cooperation among member states to promote a harmonized and effective intellectual property system. So, for the establishment of all intellectual property organization, so some previous establishments also there. So, what are the historical background of the establishment of World Intellectual Property Organization? So before 1970, before 19th century, the existence of any international convention in the field of intellectual property was not there in the universal one, but in the domestic laws, diversity of domestic laws, there are so many legislations were there to protect the intellectual property rights. But in the second half of the 19th century, the development of internationally oriented flow of technology and the increase of international trade made harmonization of industrial property laws because of the urgent need in the patent and trademarks field. So first, there is a Vienna exhibition. As we are starting today, I discussed that there is a government of Austria and Germany. They invited some persons who are having their patents. Can you please disclose? We should keep a universal protection to not infringe that. But due to the lack of legal provisions in that exhibition, so many are not interested to thinking that there may be happening of any infringement. So because of that, the Vienna exhibition 1873 was not successfully developed. But during the year only, there is a Vienna conference happens, Vienna Congress. The Vienna Congress, they thinks to adopt industrial exclusive legal framework for the protection of this industrial property. So this was convened in 1883 Paris Convention. So this Paris Convention is particularly relating to the protection of industrial properties. So later in 1886, Berne Convention was happening. This Berne Convention which talks about copyright law. So protection of copyrights. These two was revised again and again with regarding to the development of technology. For example, in Brussels Conference, after that Paris Convention in 1900, there is a Brussels Conference. It adopted a revised act of Paris Convention. And later that, there is one more conference which was established, Washington DC Conference. These are all conferences are still significant, although so they want to conclude these all conferences with the main Paris Convention. So in the Stockholm Conference, 1967, they think that it is a time to integrate all the conferences and all the exhibitions results and to make a unified single organization which will protect the intellectual property rights. So because of that intention, in 1967, during the Stockholm Conference, the WIPO was established. But it was came into force in 1970. Initially, there was two secretariats. of the WIPO. One for industrial property, one for copyright. For the administration of two conventions, but in 1893, the two secretariats united. As I previously said that WIPO was later came that name from BIRPI. BIRPI. So this BIRPI is initially BIRPI is a French acronym. It is a United International Bureau for the Protection of Intellectual Property. So in 1960, the BIRPI moved from Bern to Geneva. At the 1967 diplomatic conference in Stockholm, when WIPO was established, the administrative and financial clauses of all the then existing multilateral treaties administered by the BIRPI was revised and added to the WIPO. So what are the headquarters and offices of the WIPO? So WIPO has headquarters in Geneva, Switzerland. It also has the regional offices around the world. These offices facilitate WIPO's work in different regions and promote closer collaboration with the member states. So basically the WIPO headquarters, Geneva, is a home to its administrative and operational function. And the regional offices, it facilitates work in different geographical areas. So what is the mission of WIPO? The WIPO mission is to promote innovation and creativity for the benefit of all. It aims to ensure that intellectual property rights are respected and enforced throughout the world. It promotes innovation. World Intellectual Property Organization encourages the creation of new ideas, technologies, and artistic works. And it protects creativity. So WIPO safeguards the rights of creators and innovators by ensuring that their investors' inventions, designs, and works are protected. And it also facilitates economic growth. It promotes stable and predictable of intellectual property system, which will facilitate the economic growth. And it also built a developing countries strong economic system in the developing countries. So what are the objectives of WIPO? So WIPO has works towards a number of objectives to achieve its mission. So these objectives are designed to promote a global intellectual property system that is balanced, equitable, and effective. So first objective is harmonize intellectual property laws. So due to different domestic laws and different international intellectual property protection laws, so you have to merge all laws. You have to don't fight between one law to another law. So due to this, the WIPO seeks to align intellectual property law across the different countries to create a predictable and consistent legal framework. And the second one is it strengthens the intellectual property system. So it assists the countries which are in developing and strengthening their national intellectual property systems to strengthen their intellectual property systems. And WIPO also raises an awareness campaign they raises awareness camps about importance of intellectual property rights and their role in the innovation and creativity. So, what are the members of World Intellectual Property Organization? Currently, WIPO has 193 member states in all over the world. This broad membership reflects the global scope of intellectual property and its importance in the 21st century. So the member states are 193, regional offices are 23. So regional office is nothing but already I said that, for example, if you see in the ASEAN, it is a group of members. If they registered as a one office, then it comes under regional office. Or European Union, Western Union, like this, if they forms any groups, regions, regional wise group, African Union, then it comes under this regional. Staff members are more than 1,000 plus are working. So the World Intellectual Property Organization's organizational structure. So the organizational structure reflects its diverse functions and responsibilities. It has a number of departments, divisions, and committees to work together, activities to achieve its goals. So in the topmost level, there is a Director General who leads WIPO, and in below to him, there is a departments and a divisions. So these are the specified areas, specialized areas. So for example, the patents is a specialized section. Corporates is a specialized section. Trademark is a specialized section. Like that, they segregated the departments and divisions. In the third, below that level, it comes under committees and assemblies. So these committees and assemblies provide policy guidance and oversight to the governing bodies. For example, if a regional patent office is there, for example, a national patent office is there. So for the national patent office, what type of what type of provisions should the national patent office should follow? That was decided by these committees and assemblies. So why for committees and assemblies? So these are important because it is in the grassroots levels. So this provide policy directions and oversight. These bodies brings together representatives from member states to discuss and decide on various matters relating to intellectual property. For example, standing committees, assemblies, coordination groups, advisory committees. The standing committees, especially this, provide guidance on specific areas of intellectual property. The assemblies, they bring together the representatives and discuss and adopt policies. The coordination groups are established to facilitate cooperation and information sharing between the different stakeholders involved in the intellectual property. The advisory committees. The advisory committees provide expert advice in the specific areas with regarding to this intellectual properties. What are the main functions of World Intellectual Property Organization? So basically, the WIPO performs a variety, a long range of key functions are there to achieve its mission, that is the promotion of innovation and creativity. So these functions are essential for ensuring that intellectual property rights are protected and enforced globally. So the main function, administering treaties, they make some treaties to different parties by bringing a framework to protect the intellectual property rights. The second one is providing information and resources. So the WIPO, it not only protects, it also publishes the practices or publishes the intellectual property protection, the applications with regarding to that patent holders. Then it provides the information and fostering cooperation. The WIPO encourages to harmonize the different intellectual property systems. So, because of this lot of domestic laws, so the harmonization is effective. The harmonization of the laws is necessary to grow to the international protecting system like WIPO. And the other function is providing technical assistance. As we are already discussed that the creation of the International Protection Organization provides some benefits to the patent officers, to the patents, to the national economy. So like that, in that case, we are discussing this to the national patent officers. They provide some technical assistance. And at the same time, the other function is resolving disputes. So the WIPO is also acted as a quasi-judicial function. It offers a dispute settlement mechanism also. It adopts a ADR mechanism also. So what is the role of this WIPO in global intellectual property development? So it provides a great role in fostering the development of the intellectual property through a variety of initiatives and innovatives. Especially the WIPO harmonizes the international intellectual property treaties across the countries to fostering a unified and consistent framework of the protection of intellectual property. So this WIPO, it ensures that the intellectual property rights are recognized and specifically respected globally, and it also promotes cross-border innovation and collaboration. So for that, it makes some IP treaties. As we already discussed, one of the functions, it makes the treaties. So WIPO has developed numerous international treaties, including Paris Convention for the Protection of Industrial Property, the Berne Convention for the Protection of Literary and Artistic Works, the Patent Cooperation Treaty. These treaties established common standards and principles for intellectual property protection, streamline the process for securing intellectual property in multiple countries. And the second role is that technical assistance. So WIPO has provided technical assistance to the developing countries to help strengthen the intellectual property system. So for example, most of the patents which was registered by someone else's name on the country's name, but which was excavated from these African countries. So the African countries has a bundle of minerals, rich sources. So in that case, the WIPO strengthens to help to protect, to strengthen their IP systems. So this includes training, capacity building, legal advice. So effective implementation, suggesting the effective implementing policies which was already taken by the developed countries. So this will leads to the innovation and economic growth of that countries. Next role is policy development. Policy development, the World Intellectual Property Organization, because of this different dimensions of the different domestic laws, reviewing all laws, it will give a unified and adaptable structural framework to a particular country, which it suits that country to make IP related laws on the innovation and technology. So what is the World Intellectual Property Organization initiatives for capacity building? The organization offers a wide range of capacity building initiatives. This includes training programs, capacity building programs, knowledge sharing. So in the training process, IP officials involved in the patent examinations, trademark registration, copyright administration, dispute resolutions. So these programs equip participants with the necessary knowledge, skills, and they use effective tools to manage the enforcement of intellectual property rights. And in the case of capacity building project, it makes some capacity various projects in the strengthening of intellectual property infrastructure in developing countries. And it also used as knowledge sharing. So by conducting or organizing conferences, workshops, seminars, so these are all best examples to exchange the knowledge from one party to another party in the world intellectual property. As we said, that World Intellectual Property Organization is also acted as a quasi-judicial function that it adopts a dispute resolution services for any disputes involved in the protection of intellectual property rights. So the methods of dispute resolutions adopted by the WIPO was arbitration, mediation, and expert determination. Yesterday we are talking about arbitration and mediation. In the case of arbitration, it is a formal process where the resolving IP disputes outside of the court system. In this case, the court should appoint a particular person who is expert in those fields as an arbitrator. It gives a faster resolution and at the same time cost-effective benefit to settle the dispute. And the second one is mediation. So in the mediation, a neutral third party was appointed to negotiate between the disputing parties and to reach a mutually agreeable settlement. So arbitration agreement is final and it should be binding. But in the case of mediation, unless the mediation final agreement must be documented, must put in the legal format, it cannot be comes under enforceable. Next, the third service which was adopted by the WIPO was expert determination. This is the process where a neutral expert decides on a specific technical or legal issues in an IP dispute. It is quite same like as arbitration. In the arbitration, court appoints the arbitrator, but in the expert determination, the parties can choose the experts to determine the dispute between them. So WIPO's approach, what is the WIPO's approach with regarding to the traditional knowledge and genetic resources? With regard to traditional knowledge and genetic resources, it recognizes the importance of indigenous communities and the global heritage. The aim is to strike the balance between the protecting of traditional knowledge and the genetic resources while facilitating their use for innovation and development. So, with regard to protection of traditional knowledge, WIPO supports protect traditional knowledge from misappropriation and misuse. This includes development, international framework for recognizing and safeguarding traditional knowledge, promoting awareness about importance of traditional knowledge, and encourage the use of traditional knowledge in a responsible and equitable manner. And the second approach is access and benefit sharing. This access and benefit sharing is related to genetic resources. This involves ensuring that the indigenous communities and local communities benefit from the commercial use of genetic resource. That is by ensuring the equitable access to genetic resources for the research and development and fostering sustainable utilization of these resources. And the WIPO also provides capacity building to the indigenous communities and local communities to protect their traditional knowledge and genetic resources, and at the same time international cooperation. So WIPO facilitates international cooperation on these traditional knowledge and genetic resources, promoting dialogues and collaborations between indigenous communities from different countries by frameworks for protecting and utilizing these valuable resources. So what are the challenges for the future directions of WIPO? Basically, the WIPO, because of this rapid increase of technology in the globalization period, so the WIPO faces many challenges with regarding to the adoption of this technology. So first one, emerging technologies. The challenges were the first one, emerging technologies. So due to this artificial intelligence, blockchain technology, biotechnology, nanotechnology, computer software technology, genetic resources technology, increasing of these technologies. So this WIPO needs to adopt emerging technologies. The second challenge is globalization and digitization. So globalization and digitization, due to this cross-border enforcement mechanisms, it requires a strong international cooperation. At the same time, it is very much necessary to adopt existing international framework to address online infringement and cross-border IP disputes also. The third challenge is access to intellectual property protection. Medium-sized enterprises in the developing countries, they have to protect the patent holders or intellectual property holders because on the hands of these developed countries. So most of these developed countries are always trying to exploit the low developed countries. In that case, their intellectual properties will be subjected to become theft. So in that case, the WIPO has to create more capacity building programs in those countries to strengthen their intellectual property systems. And it also maintain balancing between innovation and protection. If you see that innovation is rapid increasing, at the same time, protection of innovation, protection with regarding to that is also very necessary. So it is a small thin line between these. WIPO must strike a delicate balance between protecting intellectual property rights and promote innovation. So this requires ensuring that intellectual property laws are not overly restricted, while also addressing concerns about the potentials of intellectual property rights. It hinders competition and innovation. So these are the future challenges and future directions for the WIPO. So because of this technology advancement, WIPO has to adopt the new directions with regarding to those emerging technologies. At the same time, it has to maintain the balance between the innovation and protection. It has also addressed the globalization issues to solve the globalization issues with regarding to the infringement of the intellectual property rights. So these are all the challenges and future directions of old intellectual property organizations. So for this, the international framework for WIPO and administrative treaties in the international framework was completed. So especially during this today's class, we are discussing the Paris Convention, Patent Cooperation Treaty, and Patent Law Treaty, WIPO. Exclusively, we deal with these three. So tomorrow, we should deal with World Trade Organization and TRIPS. These are the two other essential organizations which will deal with this patent protection in international framework. Okay. If you have any doubt, then you can ask me. Sir?
Sir, you have completed?
No, sir. Yes, sir.
Yeah, students, any doubts you can ask and you can interact with the faculty.
Yeah, I have already invited them.
Miss Anjali, Mr. Anil,
I think
they're okay. Anyhow, no problem. Thank you, sir. Tomorrow
okay,
again.
Yes,
tomorrow
sir.
again we will meet for the same time.
Okay.
Okay.
Okay, sir. Thank you.
Okay. Thank you. Thank you very much.
Thank you, sir.